The U.S. Department of Justice has told lawmakers it's released all the legally required files related to convicted sex offender Jeffrey Epstein. In a letter to Congress, the Justice Department described the redactions it made in the Epstein files. It also listed numerous high-profile people mentioned in the documents, even if some had no interactions with Epstein. Some lawmakers insist many significant files remain unpublished. Republican Congressman Thomas Massie has accused the Trump administration of attempting to stall the full release. I spoke about this a short while ago with Scott Lucas. I asked him for his analysis of the Justice Department's claim that it has now released all Epstein files it was required to.
The latest statement by the Justice Department and Attorney General Pam Bondi, which was a legally required statement under the bill passed last November for the release of the Epstein files, it's an ongoing stonewall to try to protect powerful individuals, and that may include Donald Trump.
Hey friends, Adam here. What just happened? A federal judge has issued a contempt order with Pam Bondi's name on it. The dramatic visuals circulating online, Bondi rushing past cameras with Epstein files, are recreations, not real footage. But the legal threat behind them is very real. No one, not even a former attorney general, gets to pick and choose which court orders to follow. The judiciary has run out of patience, and the machinery of contempt, bench warrants, sanctions, enforcement, is now in motion.
Out to the fallout, and it continues over the Justice Department's failure to meet the deadline to release all, that's what the law requires, all of the Jeffrey Epstein files. Democratic Congressman Ro Khanna and Republican Congressman Thomas Massie, they authored the law, announced late last night that they will bring inherent contempt charges against Attorney General Pam Bondi. In a statement, Khanna called the DOJ's failure to comply with the Epstein Files Transparency Act, quote, an obstruction of justice, unquote. CBS News Department of Justice reporter Jake Rosen joins me now. Jake, walk me through what this means that the two lawmakers are trying to set in motion and what it might mean for the Attorney General, if anything.
Well, what it might mean, Major, is a potential $5,000 a day fine after a 30-day grace period. Our audience will remember on the 19th of this month is when these Epstein files were due in full to be delivered to the American people in some kind of searchable format. That has not happened. We've seen a trickle come out even as early as overnight from Monday into Tuesday.
Let us wade into the murky waters of the actual battlefield Bondi finds herself navigating, because the documented, verifiable, on-the-record reality is already so saturated with legal jeopardy that it renders the cinematic speculation almost redundant. We start where all the shadows in this story converge: the Epstein files. The cache of documents that has become the modern equivalent of the Pandora's box for the political elite.
Breaking right now, the Justice Department has unveiled a trove of records from the Jeffrey Epstein files. These files just being made public in the last 15 minutes, and even more are expected to be released in the coming weeks. And this comes after Trump reversed his longstanding opposition to the release under mounting political pressure.
During her brief but volcanic tenure at Maine Justice, Bondi positioned herself as the bearer of transparency. She stood behind that podium with the seal of the Department of Justice gleaming over her shoulder and told the American people, with the kind of stern conviction only a former state prosecutor can muster, that the vault was open. The Epstein files are being released, she said, or words to that immediate effect. Full transparency.
Go ahead, and off topic.
On the Epstein files, does the new investigation by the Southern District of New York U.S. Attorney prevent the department from releasing all of the remaining files?
So we have released over 33,000 Epstein documents to the Hill, and we'll continue to follow the law and to have maximum transparency. Also, we will always encourage all victims to come forward.
What are the next steps, Madam Attorney General, for the DOJ regarding what we assume President Trump will sign into law with the Epstein files? Is this going to be on the Justice Department website? What are you doing here over the next 30 days, as we understand it?
We will continue to follow the law with maximum transparency while protecting victims.
Millions of pages. That was the number thrown around. Over 3 million sheets of paper, digital scans, and correspondences from the late financier's sprawling web of horror. It was supposed to be a moment of catharsis for a nation that has been demanding answers about who flew on that plane and who walked through those doors. And then, almost faster than you can say Freedom of Information Act exemption, the lawmakers actually tasked with oversight, the members of Congress who don't just read the press release but actually open the PDFs, started noticing something peculiar. The documents were bleeding black ink. We're not talking about the redaction of a social security number here, or the protection of a minor victim's identity. We're talking about vast, sweeping blocks of black that seemed surgically designed to protect not the innocent, but the well-connected. Names that keep popping up in flight logs and witness testimonies were suddenly disappearing behind the thick black bars of a Sharpie, or, more accurately, a bureaucratic exemption code. That was fissure number 1 in the dam. That was the first indication that the full transparency promised by the Attorney General might be more of a funhouse mirror reflection than a clear window. But the cracks in the foundation didn't stop spreading there. Oh no, this is where the story takes a turn into a realm that feels like it was lifted from a Le Carré novel. During the subsequent oversight tango, a truly staggering accusation bubbled up from the Congressional boiler room: surveillance. The allegation was not that Bondi was monitoring foreign agents or national security threats. The allegation was that her apparatus, the immense power of the Department of Justice, was being aimed inward at a Democratic lawmaker who was actively digging through the Epstein documents. Let that marinate in your mind for just a moment. The scenario painted is one where the top lawyer in the country is accused of tracking the search history of a sitting member of Congress, watching what keywords they typed into a database, monitoring which connections they were attempting to unearth while performing their constitutionally mandated oversight duties. This is not a parking ticket. This is not a misunderstanding about a filing deadline. This is the kind of allegation that, in any previous administration, Republican or Democrat, would have triggered an immediate and seismic constitutional crisis. It is the kind of thing that used to be a career ender, a reputation incinerator. Yet, in the swirling maelstrom of the current political climate, it became a Tuesday. She survived it not through vindication, but through the inertia of the news cycle and the subsequent, perhaps more convenient, act of being removed from the post. Are you kidding me with this? And then we arrive at the central, unyielding, concrete pillar of this entire legal storm, the subpoena fight. This is the procedural linchpin that sets the stage for every arrest warrant headline you have seen plastered across social media. The House Oversight Committee, wielding its gavel like a hammer, demanded that Pam Bondi appear for a deposition, not a friendly coffee chat. A closed-door, under-oath, transcript-taken deposition concerning the very heart of the Epstein file redactions and the aforementioned surveillance allegations. They issued a subpoena. That's not a suggestion. That's not a "we'd really appreciate it if you had time" invitation. It is a legal instrument backed by the full weight of the legislative branch of the United States government. And what did Pam Bondi do? She ghosted them. She didn't show. The response from her legal team was not an invocation of executive privilege that could be litigated. It was not a request for an accommodation due to a scheduling conflict. It was a technicality so flimsy, so utterly Perry Mason meets Weekend at Bernie's, that you have to laugh to keep from weeping for the rule of law. Her attorneys argued that the subpoena was, wait for it, invalid. Why? Because the piece of paper addressed her as Attorney General, and by the time the calendar date of the deposition rolled around, she had been given the axe by Donald Trump. She was fired. She was a private citizen. The job title on the envelope was wrong. That's the argument. That's the dodge. They looked Congress square in the eye and said, "You used the wrong name tag, so we don't have to play." This is not a parody account on X. This is a real legal filing submitted by a former Attorney General of the United States. As of this moment, that deposition remains unfulfilled. The information Congress is legally entitled to remains locked away. The questions about who signed off on those redactions and who knew about the surveillance of a lawmaker's search queries remain dangling in the void, unanswered under the penalty of perjury. That is the present tense reality. That is the live ammo situation. And in this environment of evasion and procedural sleight of hand, the narrative of a judge losing patience and reaching for the contempt power isn't some fever dream conjured up for clicks. It is a visualization of a very real, very accessible set of legal consequences. Congressional contempt, criminal contempt referrals, the almost mythical power of inherent contempt, and the ever-looming hammer of federal court contempt. Every single one of these tools is sitting in the shed, polished and ready. The question hanging over the Potomac like a summer storm isn't if they can be used, because the case law is unequivocal that they can be. The question is whether anyone in this current configuration of power has the stomach to pull them off the shelf. Let's pump the brakes and walk through the mechanics of how this would actually unfold, because the surface-level analysis on cable television tends to skip the good stuff, and the good stuff is where the fear lives. Let's start with contempt of Congress. This is the yellow brick road that Steve Bannon and Peter Navarro strolled down, and it led them directly to a cell in a federal detention center. The process is straightforward in its design, if sluggish in its execution. A congressional committee issues a subpoena. The target stiff-arms the committee. The committee holds a vote. They vote to hold the target in contempt. That resolution is then packaged up with a bow and referred to the United States Department of Justice for prosecution. The DOJ then makes the call on whether to pursue criminal charges. Bannon went through it. Navarro went through it. Both were convicted. Both did real time. 4 months apiece in a federal prison. This is not ancient history from the Whiskey Rebellion. This is recent, tangible, and directly applicable precedent. Defying a congressional subpoena can, and absolutely does, lead to incarceration. Now, for Bondi, there is an elephant in the room the size of the RFK building. The Justice Department currently answers to the man who fired her, which is also the man who appointed her. This creates a political force field around a standard contempt referral. The new Attorney General, or whoever is acting in that capacity, would have to sign off on prosecuting a former colleague and Trump loyalist. Given the current administration's track record of defending its own flank, a referral from Congress might end up in a drawer somewhere, collecting dust until the political weather changes. That is a genuine bottleneck. But here is where the story gets interesting, and where Bondi's legal team probably loses the most sleep. There are bypass routes around that bottleneck. Enter inherent contempt. This is the nuclear option that Congress keeps in a glass case labeled break only in case of constitutional emergency. Under this doctrine, Congress does not need the Justice Department to act. They do not need a U.S. attorney to file charges. The Constitution grants the legislative branch the power to police its own proceedings. This means the sergeant-at-arms of the House or Senate can be directed to physically detain an individual who is obstructing the work of the legislature. Congress can arrest you. Congress can hold you. Congress can levy fines directly from the Treasury. Yes, the last time this power was truly flexed in a high-profile way was back when they were wearing powdered wigs and riding horses. But the power didn't evaporate. It's still in Article 1. Legal scholars across the ideological spectrum have been whispering that if the legislative branch ever wanted to reclaim its relevance in the separation of powers, inherent contempt is the sledgehammer waiting in the corner. Imagine the optics. Imagine the legal firestorm. But also, imagine the raw constitutional authorization that would back it up. If the political will ever materializes in a way that overcomes institutional timidity, that tool is operational. Then we arrive at the specific arena where the judge orders arrest thumbnail finds its strongest footing, civil contempt in federal court. If a federal judge, and this is the crucial distinction, a single Article 3 judge with lifetime tenure and nothing to prove, issues an order compelling Pam Bondi to produce documents or testify, and she stiff-arms that judge the way she stiff-armed Congress, the judge does not need to make a phone call to the DOJ. The judge just acts. Civil contempt is designed not to punish past behavior, but to coerce future compliance. It is the legal equivalent of twisting someone's arm until they hand over the keys. The judge can impose daily fines that escalate like a taxi meter from hell. $5,000 a day. $10,000. The meter runs until the documents appear or the testimony is given. And in the most extreme cinematic-grade cases of defiance, civil contempt can include incarceration. The judge can order the U.S. Marshals to take the contemnor into custody and hold them until they decide to purge themselves of the contempt by finally complying with the order. This is a power vested solely in the judiciary, and it is one of the few mechanisms in American law that can actually bring a powerful, recalcitrant former official to their knees without any input from the executive branch. And let's not forget the sharper, more punitive blade, criminal contempt of court. This is different from the congressional variety. This is when a judge looks at the conduct of a party and determines that their failure to obey an order wasn't just a disagreement, but an active, willful obstruction of the administration of justice. If a judge ordered the preservation and production of specific documents, and there is evidence, say a security log or a time-stamped video, that those documents were removed from a designated space after the order was signed, that is not just a discovery dispute. That is a potential crime. Criminal contempt can result in a fixed jail sentence, independent of the underlying case. It does not require a separate trial by jury in many circuits. It is the judge's swift sword. When you stack these legal mechanisms next to each other, congressional referral, inherent detention, civil coercion, criminal punishment, the viral scenario of a judge dropping the hammer becomes less like a sci-fi fantasy and more like a pending weather report. The tools exist. The precedents are not just theoretical. They have been tested in the fires of the last half-decade. The political atmosphere is thick with tension. And Pam Bondi's strategic playbook of running out the clock and hiding behind the procedural curtains has created precisely the kind of environment where a judge, one day, might just decide that the adults in the room have had enough. Now let's get into the specific, almost noirish detail that makes the thumbnail artists salivate, the document removal angle. The visual of Bondi hustling boxes out of a courthouse is, as we have established, a creative flourish for the algorithm. But the underlying terror that drives that visual, the fear that evidence is being vanished in real time, is not a creative flourish. It is the central anxiety of every oversight investigation currently looking at this administration. Lawmakers and their investigative counsels have been sounding the alarm about a pattern of data disappearing into the ether. They talk about documents being lost in transit. They talk about files being migrated to systems that, conveniently, nobody on the current staff can access anymore. They talk about retention policies being violated and servers being scrubbed. These are not the complaints of paranoid conspiracy theorists. These are the formal grievances of the United States Congress regarding the nation's top law enforcement agency. And they fit a pattern of behavior regarding document preservation that has been a recurring theme in the broader Trump orbit. The Epstein file redactions were just the most public-facing example. Underneath that, there are swirling questions about how Justice Department emails were archived or not archived, concerns about encrypted messaging apps like Signal being used for official business in ways that circumvent the Federal Records Act, and a general, pervasive fog of uncertainty about where specific high-stakes memoranda ended up. Each one of these data points, in isolation, could be dismissed with a shrug and a claim of bureaucratic incompetence. The system glitched. The server migration is ongoing. We're looking into it. But when you string them together like pearls on a necklace, it starts to look less like incompetence and more like a feature of the system. It's a pattern of an administration that appears to view document preservation laws the way a teenager views a curfew, as an annoying suggestion to be creatively circumvented. And here is the cold, hard reality of the federal rules that Bondi swore an oath to uphold. Preservation is not a suggestion. It is a legal duty that attaches the very instant litigation is reasonably anticipated. There are statutes, specific and unforgiving, that mandate the retention of federal records. There are court rules that authorize severe sanctions for the destruction of evidence, even if that destruction was merely negligent rather than intentional. This brings us to a word that strikes more fear into the heart of a defense lawyer than a mistrial motion: spoliation. Spoliation is the legal term for the loss, destruction, or material alteration of evidence that was required to be preserved. When a judge finds that spoliation has occurred, the remedies are not just a slap on the wrist. They are nuclear. The most devastating remedy is the adverse inference instruction. A judge can look the jury in the eye and say, "Ladies and gentlemen of the jury, the evidence that used to exist in that box, the evidence that the defendant lost, you are permitted to assume that evidence would have been devastating to the defendant's case. You want to talk about a game changer? That's the legal equivalent of a walk-off grand slam. It shifts the entire burden of the narrative. The party that lost the documents doesn't just have to explain the loss. They have to overcome the court's explicit presumption that the lost evidence proved their guilt or liability. For a former attorney general like Pam Bondi, who is already under a microscope, any credible whisper of spoliation could infect every single legal proceeding she touches, every civil case, every congressional inquiry, every bar complaint. All of them could adopt the adverse inference. All of them could proceed under the shadow of, "We know what you probably did with those files." And let's be clear about the distinction between what protects her now and what protected her then. Being fired by Donald Trump did not hand Pam Bondi a get-out-of-jail-free card. It just shuffled the deck of her problems. While she was sitting in the big chair at Main Justice, she was covered by the institutional muscle of the Department of Justice. The Solicitor General's office could intervene. DOJ lawyers could argue sovereign immunity. There were layers of procedural armor available to a sitting AG that simply vaporized the moment you hand in your badge. As a former attorney general, she is now just a licensed attorney in the state of Florida and a private citizen with a very high-profile target on her back. She is more exposed to private civil lawsuits from victims or watchdog groups. She is more susceptible to the slow grinding gears of the Florida Bar Association, which has jurisdiction over her law license. She is more vulnerable to having to pay for her own defense counsel out of pocket, while fending off requests for documents that no longer fall under the umbrella of official duties. And speaking of the Florida Bar, this is the path that is less flashy than an arrest, but potentially just as lethal to her long-term livelihood. Bar associations are not designed for speed. They move with the deliberate tectonic pace of a glacier. But they do move, and they take allegations of professional misconduct, especially those involving dishonesty, fraud, or obstruction of justice, extremely seriously. The allegations swirling around Bondi's handling of the Epstein files and the potential misrepresentations about full transparency go directly to the core ethical duties of candor and fairness that govern every lawyer in Florida. A public reprimand would be a stain. A suspension would be a career interruption. Disbarment? For a former Attorney General of the United States, that would be a historical marker of disgrace that no future lobbying gig or Fox News contributor contract could ever fully erase. So, let's strip away the green screen and the clickbait arrows for a second and look at the actual architecture of what is happening. The real threat to Pam Bondi isn't necessarily the dramatic perp walk arrest in a courthouse lobby. The real threat is the mountain of paperwork piling up in dockets across the District of Columbia and Tallahassee. It is the slow, inexorable grind of the legal system's bureaucracy. It is the fact that every motion filed by a congressional lawyer, every grievance filed with a state bar, every discovery request in a civil suit adds another brick to the wall. Eventually, the wall gets high enough that you can't see over it anymore. The consequences arrive not with a bang, but with a certified mail receipt. They arrive as a notice of disciplinary hearing. They arrive as an order to show cause why you should not be held in contempt. They arrive as a judgment that says your professional life as you knew it is over. And here is the ultimate irony of the mega loyalist Attorney General. Loyalty to the top of the ticket did not shield her from the fallout. In fact, it accelerated her exposure. She took the actions she took, she made the representations she made, and she fought the subpoenas the way she did precisely because she was playing a role in a larger political drama. But when the music stopped and the cast changed, she was left standing in the spotlight, holding the bag of legal liabilities all by herself. The people who cheered her appointment are now watching her navigate a minefield that her own decisions helped to lay. What should you be watching for as this slow-motion car crash continues to unfold? First, keep a very close eye on the congressional docket. The House Oversight Committee has a long memory. The subpoena that Bondi dodged with the wrong title technicality isn't going to just sit there forever. They may reissue it with her name spelled correctly and her current title as former Attorney General. If she dodges again, the contempt referral becomes a live grenade. Second, monitor the administrative filings in Florida. The bar complaints might be under seal initially, but if the bar opens a formal investigation, word will leak. That is the kind of quiet, professional death knell that doesn't trend on social media, but changes lives. Third, stay tuned for the whistleblower effect. In cases this volatile, with this many staffers and this much political turnover, someone always talks. A former deputy who saw an email, a paralegal who kept a copy of a log, a contractor who saw something they weren't supposed to see. The document discoveries in this saga are far from finished. The big picture takeaway is this. The arrest order narrative is so potent because it visualizes a bureaucratic truth that is hard to film. The legal system is designed to outlast the individual. Pam Bondi might be able to outrun the cameras, but she cannot outrun the docket. She might dodge the deposition, but she cannot dodge the jurisdiction of the courts that govern her professional existence. The story of her tenure as Attorney General is not closed. The book is still being written, and the next chapter is likely to be filled with the kind of dense, procedural, and utterly devastating legal prose that makes a viral arrest video look like a short story. The grind is real, and in this case, the grind might just be the punishment. All right, that is the landscape as it sits today. If this deep dive into the legal quicksand surrounding Pam Bondi resonated with you, smash that like button to confuse the algorithm. Subscribe if you want to stay ahead of the next filing, and drop a comment down below. I read them all. What do you think comes crashing down first? A formal contempt referral from Congress that actually has teeth? A quiet but catastrophic finding from the Florida bar? Or a leak of a document that redefines the entire public understanding of the Epstein file redactions? Let me know what your gut tells you. Because in the next video, we are isolating the one specific overlooked action from Bondi's tumultuous tenure that is most likely to be the tripwire for the worst of the legal consequences. And trust me when I tell you, it is not the one you're expecting. You won't guess it.